In the digital age, social media has become a central hub for personal expression, news dissemination, and public discourse. However, this ease of communication brings with it the increased risk of defamation disputes, where statements made online can lead to significant legal battles. Social media platforms, with their unprecedented reach and speed of information dissemination, have become fertile ground for claims of defamation. Statements that might have remained obscure in the past can now go viral in hours, reaching vast audiences and potentially causing significant reputational harm. Defamation involves making a false statement about someone that damaged their reputation. Legal standards for defamation include proving the statement was false, communicated to others, and resulted in harm. Social media complicates these criteria, blurring the lines between opinion and fact. The casual nature of social media often leads users to make off-the-cuff remarks without considering the potential legal ramifications. These platforms amplify statements, making it easier for them to be seen as defamatory. The elements that must be proved to establish defamation are a publication to one other than the person defamed, a false statement of fact, that is understood as being of and concerning the plaintiff, and tending to harm the reputation of plaintiff. If the plaintiff is a public figure, he or she must also prove actual malice. Is truth a defense to defamation claims? Yes. Truth is an absolute defense to a defamation claim. Can my opinion be defamatory? No, but merely labeling a statement as your opinion does not make it so. Courts look at whether a reasonable reader or listener could understand the statement as asserting a statement of verifiable fact. A verifiable fact is one capable of being proven true or false. This is determined in light of the context of the statement. A few courts have said that statements made in the context of an internet bulletin board or chat room are highly likely to be opinions or hyperbole, but they do look at the remark in context to see if it's likely to be seen as a true statement by the viewer. How do courts look at the context of a statement? For a blog, a court would likely start with the general tenor, setting, and format of the blog, as well as the context of the links through which the user accessed the particular entry. Next, the court would look at the specific context and content of the blog entry, analyzing the extent of figurative or hyperbolic language used and the reasonable expectations of the blog's audience. Context is critical. What is libel per se? When libel is clear on its face, without the need for any explanatory matter, it is called libel per se. The following are often found to be libelous per se: a statement that falsely charges any person with crime or with having been indicted, convicted, or punished for crime, imputes in him the present existence of an infectious, contagious, or loathsome disease, tends directly to injure him in respect to his office, profession, trade, or business, either by imputing to him general disqualification in those respects that the office or other occupation peculiarly requires, or by imputing something with reference to his office, profession, trade, or business that has a natural tendency to lessen its profits, imputes to him impotence or a want of chastity. Again, context still matters. What is false light claim? Some states allow people to sue for damages that arise when others place them in a false light. Information presented in a false light is portrayed as factual, but creates a false impression about the plaintiff, i.e., a photograph of plaintiffs in an article about abuse, because it creates the impression that the depicted persons are victims of abuse. False light claims are subject to the constitutional protections. Note of importance: the right to seclusion. What is intrusion into seclusion? Intrusion into seclusion occurs when you intrude upon the solitude or seclusion of another person or his private affairs or concerns, if the intrusion would be highly offensive to a reasonable person. It generally comes up in the context of paparazzi photographing celebrities, but covers any reasonable expectation of privacy that is intruded upon. If the person intruded upon gave you consent to do it, i.e., gave you permission to take his picture or write about him, then you have a defense against this claim. The $1 million defamation judgment against a YouTuber. Dan Grater, a YouTube personality renowned for his swift aircraft accident analyses, was recently embroiled in a defamation lawsuit that transcended his typical aviation commentary. He was slated to attend a damages hearing on August 16th, but eyewitness Dan Milliken reported Grider's absence. Consequently, Judge John P. Chupp mandated Grider to compensate Charles Cook to the tune of $1,081,667. Grider and his legal team defended the contentious videos as expressions of free speech, underscoring their public service nature aimed at averting future plane crashes. However, this defense conveniently sidestepped Grider's direct communications with Cook and his comments on YouTube. Notwithstanding Grider's defense, the judge's previous ruling from June stood firm, leading to the August 16th verdict. Defamation can be a varied and complex legal battle. Further information and resources are included at the end of this presentation and in the description below. Thank you for listening.